A relationship based on trust and assumptions is the way David Teale, former Procurator Fiscal in Scotland, characterised the relationship between the Procurator Fiscal's office and the Post Office as a specialist reporting agency. There seems to be little formal agreement or even anything other than each other's understanding of the awareness of what the other side should have been doing. No policy, no protocol, no formalised agreements between the specialist reporting agencies and the Procurator's Fiscal's office, which seems to leave several potential holes and undue influences over the decision to bring a prosecution based not upon the evidence but upon the investigator's report. We'll explore the Post Office's relationship with the Procurator Fiscal more as we analyse the evidence when we jump into the inquiry now.
Can we look, please, at the relationship with the Post Office? I just want to try and to tap into your long experience as a Procurator Fiscal to hear about the way in which the Post Office and the Procurator Fiscal interacted when the Post Office was acting as a specialist reporting agency. Now, we've been told by Kenneth Donnelly in his witness statement that the Crown Office and Procurator Fiscal Service has been unable to identify any document at all issued by the Procurator Fiscal to the Post Office about prosecutions before the 5th of September 2013. Are you aware of any document, policy, protocol, something written down by which each organisation set out the expectations of the other?
No.
Mr. Donnelly has told us that no specific internal guidance was issued before 2013 that's now been identified, advising how prosecutors were to assess reports and evidence submitted to them by the Post Office. Again, does that accord with your recollection?
Yes, it does.
This does seem to leave the potential for massive issues if neither side is necessarily clear on what their responsibilities are and what the responsibilities of the other side are. That seems to leave the potential for there to be lots of gaps and things missed, for example, in terms of disclosure and other issues related to the case at hand.
And so for the 3 decades or so that you were doing this work, nothing was ever written down as to how the Procurator Fiscal is going to address proposed prosecutions by the Post Office?
No.
Now, as we've just discussed, I think it's right that when the Post Office investigator wrote a report to you, I think that was known as a standard prosecution report, is that
Yes.
right? An SPR. And I think after 2006, they were submitted via a web portal, is that right?
Yes.
You've explained that that would not attach the witness statements to it.
It may have, but by and large not.
It wouldn't attach the exhibits or the productions to it.
No.
And so your decision was based solely on what the investigator chose to reveal in the report.
Correct.
Did, to your mind, the investigator have a duty of cander to you in the same way as in England and Wales when one lays an information before a magistrate's court seeking a summons, there's such a duty of cander?
Of course.
In other words, they owed a heightened responsibility to tell you of anything adverse to their case.
Of course.
Not having to review the evidence before passing it through to the next stage, I appreciate reviewing the evidence would take a lot longer than the report, but also that would be a lot more accurate than relying on the specialist reporting agency, including everything, not missing anything, not misrepresenting anything in this report. So it does seem to leave a massive potential for issues to arise there in cases that are brought. I mean, if we take it to the extreme, the report could say completely the opposite to what the evidence says, could say things are there that aren't, or things that aren't there are. And it just seems like a bit of a nightmare scenario. I mean, I wonder whether this is still in place now, but it seems to lay open the potential for many cases to be brought, or indeed not brought, incorrectly.
And so that would ensure, would it, if discharged, that your decision was made in the interest of justice rather than just the interests of the, in this case, Post Office.
Correct.
What safeguards were in place to ensure that the Procurator Fiscal was getting the full picture from the investigating officer in the report?
I don't know if there were any safeguards. It was understood by the reporting agency that they had to have a duty of candour.
So understood by them, but obviously never formalised in an agreement that this is your responsibility and this is ours. So presumably, if there is any dispute, they could say, well, I thought that was the Procurator Fiscal job. And Procurator Fiscal could say, I thought that was the Post Office's job. And it really leaves the potential for major misunderstanding.
They may not summarise all of the evidence, mightn't they?
That's a possibility that they might not, yes.
They might mis-summarise the evidence.
Correct.
They might not fully summarise what an exhibit or the exhibit showed.
Correct.
They might mis-summarise what an exhibit showed.
Correct.
They may not summarise what happened in the interview.
Correct. Properly, yes.
Sorry?
They may not properly summarise what happened
Yes.
in the interview, yes.
I.e. getting over to you the full nuances of what happened in an interview.
If there were vital nuances, correct.
Yes. You wouldn't have any means of knowing that.
At that early stage, no.
So you would have to take it on trust that everything was being done correctly by all investigators in all cases.
At that stage of report, yes.
Were the Post Office cases directed within the Procurator Fiscal's service to one specific team to consider?
Not in the sort of offices that I worked in, which are remote and manned really just by me.
So they were they weren't all directed to a central office. They were spread across whichever jurisdiction the Procurator Fiscal covered according to where the branch was situated.
Yes.
And so there wasn't a process of allocation, that just naturally followed jurisdiction, is that right?
Correct.
And
they're having to take a lot on trust here, aren't they, from the Post Office, which could be quite significant later on in determining whether indeed some of these cases should have been brought in, including the one that's being highlighted here.
so there wouldn't have been, is this right, any sort of cross-sharing of information within the Procurator Fiscal about issues or problems that the Post Office cases may have presented?
No.
Do you recall taking cases involving subpostmasters before the introduction of the Horizon computer system in 2000?
No, I can't recall.
And I think you told us that the only one that you took post-2000 was this one, William Corm.
Correct.
How would you describe the Procurator Fiscal's relationship with the Post Office when it was acting as a specialist reporting agency, so far as you could see from your, as you said, quite remote jurisdiction?
Yeah, it was fine.
Would you take any steps to interrogate the suggestions and findings presented to you in a Post Office investigator's report?
You mean the SPR?
Yes.
I could, yes.
Or would you?
So he could, but presumably that would require looking at the evidence. So I guess the key thing is here, did he in this case?
You ordinarily engage with the investigation manager at the Post Office in a dialogue. This is pre-decision to prosecute.
Yes, I could and would if it was necessary.
And what might make it necessary?
Lack of clarity.
Would you typically go back with questions or ask for further inquiries to be conducted?
Well, when you say typically,
Yes.
I've said that I hadn't had any cases between 2000 and 2008. So typically is quite a difficult question to answer.
What about the cases involving the Post rather than subpostmasters?
They're in the 90s, 80s, I can't remember.
Did you ever engage with anyone other than the investigation manager within the Post Office?
Not that I can remember.
Taking your evidence on this as a whole, would it be fair to say that you worked on an assumption that the Post Office investigator had pursued all reasonable lines of inquiry, including those that pointed away from the guilt of the accused and had fully and fairly summarised all of the witness and exhibit evidence, documentary evidence in their report?
Yes, of course.
And you took that on trust?
Yes.